Right Honorable Speaker, a judgment was delivered on Friday in Supreme Court Constitutional Appeal
Procedure.
number 2.
Attorney General, we have procedure.
We are in a very complicated situation. The Attorney General is the one who wanted the military to try a civilian. He is the one who went to court. He is therefore a party to this case. So the procedural issue I am raising is whether after his comment, you will allow us, those who subscribe to the other party also, to make some comments, because he's a party. This one, Honorable Chiriowa, is the one who wanted the military to try with civilians.
Yeah, thank you. Don't look at him as a party to the case now. I look at him as a chief legal advisor of government who was given directives to implement by the court. So it's from that background. Now we are no longer having issues. The issues were settled at court level. Number two, Honorable, you know, I'm usually generous on such issues. This is part of my communication. I gave a colleague a chance to speak here. After speaking, I saw him on TV saying the speaker doesn't allow us to speak. So I wanted to drop him a call and say, but my brother, today you spoke 4 times in the house, and then you're now on TV saying the speaker doesn't allow us to speak. And when you're speaking, he said, no, I was the presiding officer that day. So, but it happens, eh? It's part of, we are in politics, we are in many things, but I will allow you, honorable colleagues, because I did this because of the many calls I received from colleagues. That's why I said, Honorable Attorney General, please.
The General Court Martial should provide a list of all pending criminal cases involving members of the UPDF pending before the court martial that fall within the categories of transfer for onward transmission to the courts for determination of the appropriate court to handle the matter. 4, the Director of Public Prosecutions is advised to liaise with the General Court Martial and the UPDF to take over the conduct of the ongoing criminal trials that have been identified for transfer. 5, the Uganda Prisons Authorities are advised to await the process above and orders of competent courts regarding any matters concerning detention of accused persons hitherto facing trial in the military courts. 6, the Ministry of Defense and Veteran Affairs is also advised to immediately commence consideration of the recommendations of the Supreme Court with a view to introducing appropriate amendments to the UPDF Act. Right Honorable Speaker and Honorable colleagues, I have also written to the Honorable the Chief Justice and requested the Honorable the Chief Justice to advising him that we have commenced the implementation of the court orders and sought for advice on the person with whom the DPP should liaise for purposes of effecting these orders.
Legally. Do not forget that until Friday 31st, there was a decision of the Constitutional Court which declared that this is not a court of law. So whatever they have been doing, they secured an interim order from the Supreme Court, and the order was to stay execution. Execution in this case was purely the transfer of files from the General Court Martial or from the Courts Martial to the civil courts. You could not stay a declaration. You can't stay a declaration. That declaration, that interim order was used by the General Court Martial, not DPP, to continue and to commence fresh prosecutions. Thirdly, Right Honorable Speaker, from the Attorney General's communication, I have not even had anything to do with timelines. Timelines, so as long as they are doing their consultations, these people can be in prison now on orders of the Attorney General. Where, under the law, does the Attorney General get the powers to remand or continue an illegal remand or to detain? Literally what he has done is to amend the orders of court.
Yesterday, our lawyers who represent Dr. Besigye and Ajobed visited the Commissioner General of Prisons. And he said his understanding was that people needed to leave, Besigye and Ajobed needed to leave his prison on Friday when the judgment became effective. And he said he was there seated waiting for the Attorney General. Up to yesterday, the Attorney General had disappeared from him.
I can do. Right, Honorable Speaker, I do not want to end at criticizing and critiquing my brother. I think I want to give some way forward. If I were in his unenviable position, this is what I would do. From Friday through to Monday, I would not sleep. I would require the information from the General Court Martial relating to all prisoners that are held on orders of the General Court Martial, now deceased. From that point, I would advise government to sieve out all political prisoners, matters which are not pure crime, and say, let us go and do the honorable thing of withdrawing. That someone can continue to be in prison, and the Attorney General is busy advising on somebody who was putting on a beret, a red beret, whether he should remain in prison. The third thing I would do, and for more than four years now, third thing I would do is to advise the police to immediately approach the General Court Martial, obtain all those files where we feel it is pure crime, a suspicion of crime, not suspicion of politics. Then I would advise that police would get those people from wherever they are upon release. But for you, you cannot say you are complying with the court order without releasing these people. At least do the ugly thing you've been doing of arresting them at the entrance or exit of the prison, the same way you've been arresting them from court. But any continuity in detention is illegal. Finally, I am concerned as a leader in this country. Immediately upon release of the judgment, Colonel Chris Magezi, who is said to be an assistant to General Muhoozi Kainerugaba, issued a statement which he called the official statement from the UPDF. And it was clear and categorical. They shall not be released until General Museveni, the commander-in-chief, gives us orders to release them. And that is the basis upon which we challenged the constitutionality of the court-martial, because it is dependent on orders of the chairman of the High Command, who is General Museveni. Membership includes his son, who is now tweeting to say we cannot release. Mr. Speaker, for how long are we going to continue like this as a country? You have a dignified Attorney General. That man knows the law, by the way. Even when he chooses to disobey or to ill-advise, at least he knows the law. Now, we receive another statement from the president. Half of it was dignified. The second half was very dignifying. You hear from the president, and what he says that this country is not governed by judges and lawyers, where I agree. But this country is governed by a constitution. Anybody who does not want to obey this constitution should give us our peace by leaving. I am concerned about the tweets of General Kainerugaba. You saw when he said that he was going to attack the mercenaries in Congo. A few days later, it happened. How are our neighbors going to take us? You crack a war inside, you crack a war outside. Why? Is it the Constitution, Mr. Speaker?
Thank you.
DPP shall not be under the control or manipulation of anybody. So nobody is meant to give any order or directive to the DPP. What the learned Attorney General seems to be saying is that now the court-martial is going to be directing the DPP to say, we have these matters, you take them up. That's against the law. What's meant to happen, Right Honorable Speaker, is that the court-martial is meant to issue with immediacy release orders for these people, because the court-martial no longer has any authority over these people. Completely release them.
Actually, from the communication of the Attorney General, they have actually already interfered with the independence of the DPP by telling her to go and liaise. So it is not that the DPP is not under control. They have already controlled her by telling her to go and liaise with the court-martial.
What is happening, Right Honorable Speaker, and the Attorney General agrees, is that all players, especially the prison warders who are detaining these people, are doing so illegally. We are literally doing so in utter disregard of the constitutional provision. So we have overthrown the Constitution. But be that as it may, Mr. Speaker, my worry is in what is actually being planned by the government. Because the information we've got is that they are now trying to come up with a bill to overturn the Supreme Court judgment.
Mr. Speaker, first, I think as the Shadow Minister for Justice, I would like to convey words of acknowledgement and appreciation to the justices of the Supreme Court for coming out very clearly and boldly in delivering this judgment, which had caused great concern amongst the public and some sorts of anxiety. So I would like to thank the judiciary, the Chief Justice, and the justices who delivered this unanimous decision. Mr. Speaker, Article 126, Clause 2E, and I would like to read, says that substantive justice shall be administered without undue regard to technicalities. The learned Attorney General understands this very well. What he's trying to do is trying to delay substantive justice. The orders are as clear, and that court-martial, in my understanding, has not been disbanded. What I'd expected today or yesterday was for the court-martial to sit and say, we are now discharging all these persons that were before us, that at that time we thought we had the authority to try them. But now that court has declared, we are now discharging them. And that would be the most logical step to do. We also know that courts rely on departments and agencies and authorities of government to function. Courts do not have the force to go and pick people, just like the speaker you observed here. As parliament, we cannot go to prisons and open those padlocks. Courts rely on the goodwill of the executive in implementing the decisions that they issue. So I expected that the Attorney General, the DPP, the Commissioner General of Prisons, whoever is involved, to comply with this. The last point I would like to ask the Attorney General. You have read to us very good advice you have rendered. I would like to know whether you rendered that advice to the President. The President quoted you, that he called you on phone, and you seem to have given him an advice that does not match with what you are telling us here. Would you now? And Mr. Speaker, this letter from the President is in the open. I don't need to go through it. But he quoted that he got in touch with the Attorney General, who explained to him certain things. I understand that the Attorney General, being a party to the suit at that time in the heat of the moment, having lost that big case, you would have lost a little bit of your composure. But would you now clarify to us? And I've ever been to the Supreme Court as a litigant, and I lost a case. I know what it feels like. So I understand what the Attorney General went through. But would the Attorney General tell us clearly if this advice that he has told us here is exactly what he rendered to the head of the state? Because what the President wrote potentially undermines the rule of law, undermines democracy, and I thought that it is incumbent upon the Attorney General to guide the President on the next course of action. Would you clarify to us and even lay where possible, that opinion, because this is not just advice, you said a legal opinion, and there is clarity on how a legal opinion is rendered. Would we see that here, Mr. Speaker?
Thank you, colleagues in the public gallery this afternoon. We have students.
Court-martial cannot sit. So it cannot sit to make any orders that you want them to make. That's one. Number two, if there are facts that you have, Honorable Medad Segona, as a senior lawyer, if there are facts like you have stated here, the best place to take them is to the court. Yeah? Yes. Secondly, Right Honorable Speaker and Honorable colleagues, Honorable Segona should know that as a practicing advocate, after you are successful in court, you extract a decree. If you think my advice is inconsistent with what the judgment said, you should at liberty to extract a decree, have the court sign it, and use it in the premises that you would like to use it. I have read this judgment variously, and you may think that I was sleeping. I did not. I spent time reading this judgment page by page, and I word for word. And what I have advised here, I did not get from my head. I got from the judgment. The matter under discussion is not the Court of Appeal decision. The matter under discussion is the Supreme Court decision. So reference to the Court of Appeal decision, which was appealed against, is misplaced. Now, there are no timelines. I agree. But we have sent the matters to the courts which granted these orders. The courts are still clothed with the authority to make any orders that they deem appropriate. Like
point of order.
Everybody at the bar ordinarily should keep quiet. I agree with him that a successful litigant goes ahead together with the losing litigant to sign a decree, to prepare a decree jointly. If he was waiting for a decree, what was the basis of his advice? Number two, I am not aware, and he can now educate us, the law under which a losing or vanquished litigant would write to court to ask for which orders. The orders, Honorable Nwagaba says, is self-executing. Is the Attorney General, therefore, in order to mislead both the House and the country that the person who was in court when the judgment was being issued is waiting for a decree extracted by one party?
Attorney General, you want to make some clarification?
going here is a bit of a runaround, because I have told you my understanding of the judgment. And yes, and that's why maybe I lost. But what we are saying is that if you disagree with what I have written as what the court said, the arbiter is there. Now, finally, Right Honorable Speaker.
Procedure, Honorable Sashkova. Procedure.
Rem. They are not in personam. Meaning that all must abide not only the Attorney General, but the constitutional order in the country must listen and adhere. So, number two, the Honorable, the Land Attorney General, Right Honorable Speaker, did his best when he made arguments before the Supreme Court. He did his best. That is the best he could offer. Now for this House to demand and to expect a better alternative from him, I think would be too much. That
started well, appreciating each other, both sides, in terms of the swift action that the Attorney General had taken. He told you immediately how he moved. Even on Sunday he was working, even yesterday he was working. So I think that was in the right direction. Now, where we are disagreeing is the content of what maybe he has written and what he has not written. And when I was listening on the issue of the DPP, and I would want it to be very clear, I heard you using the word "I advise." I heard it several times. I advised. So meaning, if the DPP still has a discretion of taking the advice or not taking it. So that's what I was hearing. I think, honorable colleagues, also when we say the Attorney General has guided the House wrong or what, we are not making any resolution on this matter. I asked the Attorney General to give us an update. This is a matter which has been settled by court. We cannot reopen it here. We just needed an update on how far he has reached in as far as implementing the court order is concerned, because, honorable colleagues, we are raising this issue. We don't expect any other any other decision here that is going to override the decision of the Supreme Court. Attorney General, allow me to pick Honorable Okror Bosco.
I think I want to make a humble contribution to this discussion. Right, Honourable Speaker, the judgment of court of us are doing is thinking that we can read this judgment off from the original text. We have excerpts of judgments which people are reading and not understanding the exact judgment. Yes, you can say the pronouncement of court that the judgments of this nature are in rem. It is true delivered by court. But what can only be executed is an extract of a decree or an order. So, Right Honourable Speaker, we can say they are self-executing judgments. That is right. But when this is the judgment of Wunyidolo. All charges, page 194, all charges or ongoing criminal courts of law with the competent jurisdiction. The word immediate is there. It's immediately cease and be transferred. So when you are reading interpretation, it is not for Attorney General, it's for the court to settle that component. That what do you mean? Because court did not say the process of transfer is a process. It is a process. So we cannot castigate Attorney General for giving his view and all the processes that are being undertaken. But I think let's do our work. This is the real text. I beg to submit.
Thank you.
I will take you back in time. Take you back in time to a language that is now considered all matters are settled. There's no matter left for discussion. There's absolutely nothing left for resolution. There's nothing left for amendment. A request to the learned Attorney General to render an account of the implementation of the court order. They will never be able to amend a single order from my land brother Okrora has already told you. Even where the court said there must be cessation of prosecution immediately.
Point of order.
Right Honourable Speaker, the Honourable Fox Odoi is the chair of the Human Rights Committee. He is supposed to help protect the rights of Ugandans. What the Attorney General is doing is okay, and people can be in prison and wait because he's doing it orderly. Is he in order?
Honourable colleagues, how will I be determining points of order on opinions? Because these are opinions. This is Honourable Fox Odoi's opinion. This is how he has understood it. Now, how will I, where we cut for me? That's Honourable.
Thank you very much, Right Honourable Speaker, for your very wise counsel and ruling. Right Honourable Speaker, the Attorney General is in a very unenviable position. And at this very critical moment, I can only state that I have absolute faith in his knowledge of the law, the part of the Attorney General. I beg to submit.
Thank you. I had allowed Honourable Samuel Judge will begin.
Mr. Speaker, I want to thank you very much. The court martial cannot sit because of this judgment. For the court martial, they are not waiting for a decree. There are also no discussion with anyone else, but they immediately stopped functioning. And I want to thank him for release of prisoners, including Dr. Besigye, who is in Iruzira now illegally, because there is no detention warrant. There, the DPP is realizing, I have written to Supreme Court. Why didn't you render the same advice to the court martial that continue working as I liaise with the Supreme Court? Why do you think for them they needed to stop functioning immediately, but the others can continue disobeying? I am sympathetic to him. Maybe the same reason that court said military people cannot purport to be dispensing justice. Because the people were asking the Attorney General to advise, they have already expressed themselves. The CDF said Besigye can only get out of prison in a coffin. Really, what sort of advice can you give a person who thinks like that? Even if you are a professor of law, time was 3. The CDF, one of the supervisors of the General Court Martial, has said Dr. Besigye can only get out of prison in a coffin. He had even arranged to kill him. He had even identified a tree in Guru. And that's why I sympathize with you. Sometimes, sometimes these jobs, sometimes these jobs, I think we may need one time the late Professor Kidoma Kuya was asked to offer advice to the president, and he said in law, you may or may give no advice. That's how he used to talk. In this case, I choose to give no advice. That's what he told the president. One of the reasons he was eventually sacked. What advice do you give to a person who has made the statements that the CDF has made? And then the president who went to Luwero to fight, killing people because he wanted the power. Yes, in Luwero they were not hunting, they were killing. He even speaks about it, how he was robbing guns from barracks, from Kabamba to Masindi to Hoima. He writes up. Trouble is that you support him, but you don't read his book. Because if you did, all this information is there. He went to Luwero to kill, he killed, robbed the banks, including one in Kabale. And then he said he was fighting point number 1 of NRM is democracy. And he says judges don't rule. So who rules Uganda? The president and his son. That what they say is sacrosanct. Even the Attorney General, you are wasting your time. So I want the Attorney General to help me understand whether you can render an advice to 2 military men who have already expressed themselves. Finally, Mr. Speaker, the Constitution does not allow Parliament to take any decision whose effect will alter a judgment of court. In advising these military people who are not listening, the Attorney General said he was talking about an amendment. Can he tell us? And I listened to Honorable Fox Odoi very carefully, and I want to thank him. He said there's nothing to amend. But the Attorney General says they have advised him to amend. So what are you advising them to amend, sir? Thank you very much, Mr. Speaker.
Honorable Taylor John.
Thank you, Right Honorable Speaker. Speaker is the component of human rights. In the whole world, when it comes to matters, the feeling is that people's rights are being violated. And from the wording of the judgment, any continuation of detention of the prisoners infringes their rights. What the Attorney General has put, which we should put much emphasis on, is how should we do it systematically so that order is maintained in the country. It would also be ugly to wake up in the morning and then people say we have stormed the Luzira prisons to pick our people. So what I want to implore the Attorney General is to rightly advise the powers that be to have an expeditious handling of the implementation of the non-debatable orders that were made in the judgment, considering in mind that we still have a long list of individuals who are now falling in the category of people whose rights have been violated. And at this point, we also need to appreciate the position of the Attorney General, where he is the legal advisor to government. And his role is advisory. So I see us crucifying a messenger who has delivered a message.
Clarify on one issue that probably Lop raised. The decision, the issue of the position of the inmates now, all the inmates who are under the trial in the General Court Martial, all their matters are now under the jurisdiction of the courts of judicature.
Just wait, Attorney General.
Yes.
Kindly,
Yes.
Honorable colleague, take your seat. Attorney General, continue.
Yeah. So what I'm saying is that the court said, seize these matters and transfer them to us. That means that the court, the Supreme Court, handed the jurisdiction over any matter that relates to any of those people to the courts of judicature. Now, Honorable Segona, we can continue the debate. I have rendered advice. I have told you that the government has decided to comply with the court order, and we are going to comply with the court orders as have been given by the Supreme Court. I thank you.
Thank you.
9B, 1B. And the motion, Mr. Speaker, is a motion of adjournment to discuss an urgent matter of public importance. So, Speaker, and I want to thank you. You were generous in allowing us to make comments the way we did about the Supreme Court judgment. But because of the importance of this judgment, I am moving this motion, Mr. Speaker, to persuade you to adjourn the subject matter under consideration and to allow us at least an hour to discuss this matter. Why? The defeat in court was not a defeat just of the Attorney General. In fact, when Parliament was making this law, the Honorable Chiwanuka Chiriowa was not even the Attorney General. So this judgment also touches on how Parliament conducts business here. How you are advised, because the way the Chief Justice described setting up of the court martial, he said it's like asking him to go to Mulago to begin operating patients. That's what Parliament did, and any MP worth the name must take this as a very serious matter. That what we did, what Parliament did in setting up the General Court Martial was like telling a lawyer to go to Mulago to operate patients. And second, Mr. Speaker, the constitutional order in the country, this judgment touches on the constitutional order. That you have a military that has taken over management of society. The CDF is issuing one tweet after another. We are now asking Attorney General to advise him. So the motion, Mr. Speaker, of adjournment is to allow us to present these matters to the satisfaction of the public. The public now is very happy with the judiciary. It is time for the public to also be very happy with the parliament, especially because it's this parliament that established that general court martial. I am lucky I was not in that parliament. Otherwise, the words of the Chief Justice. So that's the motion, Mr. Speaker, that I am moving to adjourn consideration of the matters on the floor now to discuss a matter of urgent public importance, and that's the judgment of the Supreme Court.
Thank you. Thank you, Honorable Guide. Okay? That's why I'm here. Now, this matter goes beyond Rule 59. It goes to Rule 64. 64.2, a member who desires to move a motion of this nature, in writing, if I may read it, a member desiring to move the motion under sub-rule 1, because it's a special motions, that's adjourned.